Welcome to Short Legal Briefs with Josh Long, where experts in the natural products industry explore the intersection of business, law, and regulations. Tune in for the next 15 minutes to learn about policies and controversies affecting dietary supplement, food, and beverage brands.
Hi, everyone. Welcome to the show. I'm Josh Long. In December, the Food and Drug Administration took the position in warning letters that NAC could not be lawfully marketed in dietary supplements because it was first approved as a drug in 1963. This action caught the industry off guard, considering hundreds of supplement brands have been selling NAC for perhaps more than a quarter century. Since then, Amazon has taken action to remove NAC supplements from the market, while others continue to manufacture and sell these products. Joining me today to discuss the controversy, Kevin Bell, a partner in Washington, D.C. with the law firm Arnell Gold & Gregory, Jim Emme, CEO of Now Health Group, and Associate General Counsel and Vice President of the Council for Responsible Nutrition. Guests, welcome to the show. We're going to start our lightning round now. Jim Emme, you're in the hot seat. In 60 seconds, how has FDA's action affected the manufacturing and sale of NAC supplements?
Well, it really hasn't affected our status quo just yet. It has affected some customers who've chosen to stop selling NAC for whatever reasons. It's not clear to us just yet exactly what the issue is. We are one of those companies that have been manufacturing and marketing NAC supplements since October 1993, almost a year exactly to when DSHEA took effect in October of 1994. So it's not clear to us that there have been any adverse events from the use of NAC supplements. So one thing that we've actively tried to seek out is what is the exact issue. DSHEA does allow for situations where supplement ingredients are used in prescription drugs while the drugs are marketed concurrently, and we're just not clear as to why the stop recommendations have been made and how they've been made.
Thank you very much, Jim. Megan, we're going to pivot to you. CRN recently argued in a citizen petition filed with FDA that the agency's position regarding NAC is legally invalid or incorrect. I want to give you the opportunity to summarize one of your greatest legal arguments in your petition. Shoot.
Thank you so much. Well, appreciate being here, and we have been talking with FDA and very concerned about their position since they came out with this position warning letters in last year in July 2020. One of our biggest concerns is the unreliability of the record. They cite a 1963 warning letter, which we're concerned, 1963 drug approval, which was for an inhalable ingredient versus an ingestible ingredient, which is what NAC is, of course, is in dietary supplements, since you can't have an inhalable ingredient in dietary supplements. The record's been very difficult to verify. We've had FOIA requests into the agency to look at those 1963 records. There are handwritten dates in those records. And so a number of concerns in the way that the agency is using these difficult to verify records to try to take a product off the market that has no safety concerns, that's been on the market since prior to DSHEA. And we know supplement companies like Jim Emme's company have evidence to that. And that feeds into a concern as well that FDA is using the drug preclusion provision of DSHEA incorrectly, that it shouldn't be applied retroactively to take products off the market that were coexisting. Drugs and supplements, NAC supplements, coexisted together prior to 1994. And we've made that argument as well in our citizen petition that this was not the intent of Congress to remove these products from the market, but to have DSHEA, this provision of DSHEA, be forward-looking.
Thank you, Megan. Kevin, whenever FDA asserts in a warning letter, you can't do X, Y, or Z, your clients probably come to you and say, well, what happens if I do X, Y, and Z? Simple question for you. What are the risks that manufacturers and marketers face if they continue to sell NAC supplements, given FDA's current stance?
I think it's a good question, Josh. And I think that's part of the problem and the confusion that not only industry faces, but those of us who advise industry faces. What level of risk is that? I mean, no one would have thought that what you're going to see was Amazon come behind it and take hold of that idea. I don't think industry otherwise would have entirely pivoted the way it was forced to pivot because of Amazon's actions, because of NAC, because there really are no known health risk to NAC. So I think that when we see something like this in the form of a warning letter, you would, if you're representing the person who got the letter, that's one thing. If you're representing industry saying, what's this mean for us? Then we try to show them what the extra layer of risk is involved, and really, are we looking at a warning letter that talks about true safety issues or something like this, which a little bit of left field was brought into this. But I will tell you that when Amazon got involved and started yanking stuff off, the economic harm that started to create was right across the plate.
Thanks, Kevin. Appreciate that. Jim, I'm going to pivot back to you. Some have criticized the agency for, quote, regulating via warning letter. In other words, the agency circumventing notice and comment proceedings, and NAC may be a case in point. Simple question for you as well. Has FDA played fairly here?
Well, it depends. I'm not an attorney, but I'm going to use an attorney word phrase there. Really, it boils down as to what is the justification for the warning letter. Is it a label claim, of an unsubstantiated claim that, or a structure function claim that doesn't have a clinical trial to back it up? We don't know, and that creates the confusion. And we're not here to point a finger at the agency. We want to work with the agency. We're a company that complies. So does it seem unfair? It does to us, but we don't have all the facts right now. And we're trying to seek out those facts, through the trade groups, through our legal counsel. But so far, the agency's been unresponsive. And that, I guess that could be good or bad right now. But we would like the agency to work with us, not against us. Again, we're rule followers as a company, and we're going to continue to be that way.
Thank you, Jim. Megan, we're gonna go back to you here. Some lawyers, including Kevin, have noted that filing a citizen petition is potentially a futile endeavor, or it's a fool's errand, because FDA notoriously doesn't, substantively anyways, respond to these petitions for many years. Want to give you a chance to either address that argument or explain to the audience, why did CRN file the petition?
Sure, and we're well aware of the FDA's track record on unresponsiveness to citizen petitions. I think citizen petitions serve a number of different purposes. One here is to create the legal record to try to force the agency into a final action that could go through judicial review. Part of the big problem with warning letters is they're not considered final agency actions subject to judicial review. And so by the FDA putting out this warning letter, they've essentially created a situation where companies are now facing economic consequences because retailers like Amazon are taking the product down, but they can't get the agency to comment as to why they've made this decision and defend the legality behind the decision. So that's one of the big reasons. But it also plays a role in our advocacy. We're talking to a number of congressional allies, and providing the citizen petition to them helps them, work with FDA and really push FDA to say what's happening here, defend this position, and help industry get to a resolution.
Thank you. Kevin, Megan just mentioned what I was going to say, which is that warning letters, it's my understanding, are not final agency action, thus cannot be challenged in the courts. We know about CRN's petition. My question is this to you. What else can and should industry do to move the needle on NAC with FDA?
Well, look, certainly we believe the best thing to do, and my understanding is Natural Products Association is going to move forward with this, is to file something asking the Secretary to promulgate a regulation that says NAC is a dietary supplement. I mean, I think that's the most direct route here. A citizen's petition, I'm asking, I think to withdraw is what it was, is something that once you hit that last day before the 180 days, they often send out a letter saying they're still considering it. And really to go after FDA in court under that scenario, you often have to wait quite a while for FDA to get to the end of the road on that. So sometimes it takes years before you really can try to treat that as a true final regulatory, as a final agency action. I think the more direct route is just, and I think you need to think about CBD when you think about this, is asking the Secretary to promulgate a regulation saying NAC is a dietary supplement. I think it's a more direct route, and I think it's potentially hopefully more effective for industry.
Thank you, Kevin. Ladies and gentlemen, that concludes our lightning round. This is the portion of the program where I give our guests an opportunity to say whatever they want on NAC for as long as they want. as long as it's in 90 seconds. We'll start with Kevin Bell. What say you, Counselor?
I would say that this action by the agency, look, industry wants to work with FDA, but when something like this comes out of the woods, really out of left field, the impact it has on companies, either immediately or over time, is significant. The economic harm by that action needs to be taken into account, especially when there's been no identifiable safety risk. Now, clearly, if there's been an identifiable safety risk, you have to treat it differently and with much more urgency. But in this instance, at least the meeting I was on with FDA, they were taking comments they were going to take further consideration, but on a warning letter they sent out last August, they could not articulate a reason for the actions that they've recently taken, that they're still considering it. So in this instance, FDA needs to understand, not just trying to understand whatever regulatory scheme they're trying to enforce or have people comply with. They need to understand their actions have significant impacts to industry. And so understanding industry and what that impact is, and then really taking that into consideration, the shoot first and ask questions later and then not have an answer, that's not something that's going to be, that's not something that's helpful for industry. And so you can get congressional leaders involved, and I think that's also helpful. But the agency itself needs to know the impact it's actually having on industry when it takes an action.
Thank you, Kevin. Megan, what would you like to share with the audience in 90 seconds?
Sure. So I appreciate Kevin's comments as well. And I think that's one of the reasons we have been elevating this issue with FDA leadership, with congressional leaders. It's bigger than NAC. There's concerns about how FDA has treated the DSHEA drug preclusion provision over the years, not giving a lot of guidance around what is an article, using it to block CBD and not opening up the rulemaking process to allow hemp-derived CBD into dietary supplements. We're concerned about the fact that they're using it retroactively, and could that come down and apply to other ingredients, especially given the fact that they allowed NAC to sit on the market for over 20 years before pulling out the drug preclusion provision as a problem last summer. So I think that there's a number of reasons why we have elevated this issue, and it's elevated beyond NAC. And then I think, our other comments are to retailers and to companies that are struggling with what to do. We have, warning letters are not final agency action. I cannot stress that enough. And CRN believes that this is still very much an open issue. The agency has responded to us publicly that they do intend to respond to our comments. Again, not giving a timeline, so that's one of the reasons we thought the citizen petition would be helpful to put pressure on the agency. And so this is, we believe, very much an open position. Retailer action is premature at this point, taking products off the market. And there is a record of FDA reversing positions on warning letters. And I bring up the kind granola bars and healthy as an example of where FDA took a position in a warning letter that they then reversed. So we're hopeful that we will see something similar here.
Thank you, Megan. Jim Emmy, you get the last word.
Okay, thank you, Josh, and thank you, Kevin and Megan. It's always great to be associated with you folks. You've contributed well. From a position of Now Foods and myself, we're rule followers. We've taken a lot of steps in the last year to publicly call out companies that aren't following the rules right, even with some legal risk in doing so, but making sure that we've been fair about it, with unsubstantiated label claims, as well as just false bad products that are not good for consumers and not good for retailers. And in the same spirit of that, we're going to follow the rules here on NAC. Certainly want to work with the agency, but we're also not sitting back. Last week I was in Washington, participated in some in-person meetings. Washington is starting to open. Met with staff from Congress people and senators from Illinois, Nevada, and also directly with several members of the Dietary Supplement Caucus. NAC was one of the topics I discussed. And you know what? We were met very positively about this concern of confusion. And how the representatives and senators are interested and are going to engage the agency in a way that's productive and helpful so that we can all be on the same page. And there's not just some unilateral action without substantiation. And we're grateful for that help from Capitol Hill and look forward to more as we go forward.
Thank you very much. Ladies and gentlemen, I want to thank our guests, Kevin Bell, Jim Emmy, and Megan Olson. We'll see you in 2 weeks for another episode of Short Legal Briefs. Until then, take care.